Further hearing in the application by the Northern Ireland Human Rights Commission for judicial review.
My lady, two things from yesterday. We've put before the court the methodology for the Northern Ireland Life and Times survey. Good. And I wanted to ask the court, in particular my Lord Mance, whether he would like a note on German abortion law on serious fetal abnormality. We know the answer, but we only really got it this morning. I can do a short note for tomorrow, if that would be...
Is there some other paragraph of the draft gazettes?
Criminal Constitutional Code, which is then explained by some guidance. But rather than take up Miss Quinlivan's time now, I was going to offer a note.
Thank you.
I'm very grateful. I'm now going to swap places.
My lords, my ladies, I appear for JR 76 with Mr Devine, instructed by Stephen Chambers Solicitors. JR 76 are a mother and daughter who have judicially reviewed the Public Prosecution Service in Northern Ireland in circumstances where the mother is being prosecuted for obtaining online medical abortion pills for her daughter, who was 15 years old at the time. In the course of this intervention, we will refer you to a small number of documents on which we rely. Our written case can be found at Core Volume 5, where the third intervener, and we're behind that tab, and the reference number is MS 10382. We would also refer you to affidavit evidence from both the mother and daughter. The mother's substantive affidavit can be found again in Core Volume 5 at MS 10415. It's followed by a short supplementary affidavit. And the daughter's substantive affidavit can be found at MS 10430, again, MS 10430, again followed by a short supplementary affidavit. As with the other interveners, I have limited time, and while we rely upon our written case, we don't propose to open it. And while I will refer you to authorities, I don't, unless asked by your lordships or your ladyships, propose to open those authorities. What we propose to do is to open the factual background, not as fully as we would like, but in doing so, our focus will be particularly on the fact that at the heart of our case is a child who found herself facing a crisis pregnancy. And we will be submitting that the fact that she was a child is not just relevant, but crucial to the issue of whether the Article 3 threshold has been crossed and to the balancing exercise under Article 8. The fact that she is a child means, and the authorities we say show this, that the Article 3 threshold is lower and the interference with her Article 8 rights magnified so that the burden on the respondents of establishing proportionality is accordingly greater. We will, on a more superficial basis than we would like, remind the court, when looking at both Article 3 and Article 8, that you will be informed by the United Nations Convention on the Rights of the Child. We have left, there's a blue folder beside your lordships. The United Nations Convention on the Rights of the Child didn't make its way into the papers, so it is now added to the many papers you have. Additionally, we have, and we will refer shortly to the United Nations Committee on the Rights of the Child, their general comment number 12 on the right of the child to be heard. That's a matter on which we will briefly address you. In the context of this case, we say the importance of the voice of the child being given due weight in all matters affecting the child is an important aspect to the particular factual situation in this case. If we could go to the facts, and as my Lord Reid reminded us yesterday, in Article 3 cases, an intense focus on the facts of the case is important. Our case concerns a 15-year-old child who found herself facing a crisis pregnancy in circumstances where her relationship with her then ex-boyfriend can properly be characterised as physically and emotionally abusive, and we say that's relevant to her vulnerability, an issue which is a factor to be taken into account in looking at Article 3. On learning she was pregnant, she informed her mother. She also, just to give some context to her vulnerability, informed her ex-boyfriend, and his response was to abuse and threaten the girl, threatened to harm her in her pregnant state, and to harm any child that was born. And if I can just give you those references, they are MS 10435, paragraphs 23 to 25, and the mother also refers to this at MS 10417, paragraphs 11 and 12. In terms of her interaction with her mother assured her daughter of her support, and she was given the time, the space, and the support, given the limited time constraints there inevitably are in this context, to consider her options, to work through her options, and to identify her wishes. And one of the options was the option of termination of pregnancy, either by travelling to England or by taking abortion pills obtained online. And she very clearly articulated, and she very clearly decided that she didn't want to continue with her pregnancy. And she has articulated, and the court can look to her reasoning for doing that. I don't ask you to open the passages, although I will quote in part from them, but they are MS 10436, paragraph 29, and MS 10441, paragraph 49. And what she says, I was only 15 years old, and I was frightened by the prospect of being a mother. I was still only a child myself, and I was not sure I would be able to cope. I was still at school, I planned to do A-levels, and wanted to go to university. All of this would have been extremely difficult as a single mother. And later, when she's responding to what the Public Prosecution Service, their justification for continuing with the prosecution, she says, I could not have gone through with a pregnancy. I was totally ill-equipped to be a mother. I found the thought of having to engage with my abusive boyfriend as a father to any child I might give birth to horrific. She also states that she couldn't face the prospect of travelling to England for a termination, and that reference can be found at MS 10436, paragraph 28. And your lordships will have seen from the judgment, and your ladyships will have seen from the judgment in A, B and C versus Ireland, that there's a recognition, and you'll find the authority at Authorities Volume 3, tab 13. The court considered it evident that travelling abroad for an abortion constituted a significant psychological burden. And we say how much greater a burden for a child in the same situation. And they also commented on the physical burden and stated an abortion would be a significantly less arduous process without the need to travel. And the reference, the MS reference, is MS 852. It's paragraphs 126 and 127. But we say those observations have greater force in the context of a child. Your lordships and ladyships will see from the papers, and I don't intend to open this, but her mother accessed medical abortion pills online. She explained why she thought the manner in which she did so was safe, and she obtained them in the post, and her daughter took those pills. And she did so without significant adverse consequence. And we know this because within a week she attended her GP. She attended her GP primarily because of her mother's concerns about her emotional welfare, rather than any concern about her physical welfare. And she was referred for counselling to children and adolescent mental health services, commonly known as CAMS. Both mother and daughter attended for counselling with CAMS. And unbeknownst to them, as a result of their attendance there, they were referred to social services. Social services, in turn, refer their case to the police service. The police service contacted both CAMS and her GP service and obtained from them, without objection, without demur, her medical notes and records in relation to her attendance at both her GP and the counselling service. Nobody thought to notify the child. Nobody thought to query whether she objected or consented. So deeply intimate and personal records were disclosed by those with the duty of medical confidentiality towards her. And they now form part of the papers, the prosecution papers, upon which the prosecution rely to prosecute her mother for giving effect to her wishes, and we say for acting in her best interests. And as an aside, my lords, my ladies, on the decision of the medical professionals to give her records to the police without any consultation process, we say that that is indicative of the chilling effect of the current state of abortion law in Northern Ireland, that the reality of criminalisation of abortion has medical professions not acting in the best interests of their patient, breaching medical confidentiality, rather than looking first to what is it my patient needs. And we say that in relation to it, that that's one of the features that that features throughout the examples that your lordships and ladyships have faced, and that is the medical profession looking over their shoulder at the legalities issues rather than dealing with the patient in front of them. My lords, my ladies, if I can briefly touch upon issues for the first applicant, the mother, who we say was acutely affected by the situation her daughter faced. I invite your lordships and ladyships to look in particular at her affidavit, paragraph 10, and also paragraphs 25 to 28. And in the latter part, she records her reaction to medical notes which record that she blamed herself for the situation she found herself in.
Sorry, where was the reference again?
The reference is MS 10421, paragraphs 25 to 28. And she says, I do not doubt that I said I blame myself. I still do. At the end of the day, my daughter was and is my responsibility. She was a child. I am her mother. She was a bright child with a great future ahead of her, and yet she ended up in an abusive relationship, pregnant at the age of 15, with a boyfriend who was still threatening her. I feel responsible for the situation she found herself in as her mother, and I still feel responsible for the distress and upset she goes through as I face charges arising from what occurred. My lords and ladies, the authority for the proposition that Article 3 ill treatment inflicted on a child can, as a result, qualify a parent as a victim of that ill treatment are Mayeka versus Belgium, Authorities Bundle 13, tab 119, MS 4433, paragraphs 60 to 61. And on that theme, there is recognition of the role of a mother and the impact of her daughter's dilemmas and choices on a mother in the case PS versus Poland. And it's Authorities Volume 3, tab 20. It's paragraph 109, and it's MS 1126. I should acknowledge in that context that the discussion there is in the context of Article 8, but we say that discussion can readily be transposed to the Article 3 context. And in short form, the court says it cannot be overlooked that the interests and life prospects of the mother of a pregnant minor girl are also involved in the decision whether to carry the pregnancy to term or not. And the quote goes on, and I urge your lordships and ladyships to look at that.
And the first one was something against Belgium?
Mayeka versus Belgium.
Mayeka.
It's MS 4433, paragraph 60 to 62. My lords and ladies, an important feature of this case, and one which we say in reality is a feature of many cases involving children's rights, is that in a practical sense, a child lacks the full autonomy of adults. And when I say that, I don't mean that they don't have legal rights as adults do, but they cannot always give effect to those rights without support from an adult. In this case, this minor was dependent upon others to give effect to her wishes. She was dependent on her mother to give due weight to her views on the matter affecting her. And if I can just briefly ask you to look at this, if the child didn't have the assistance of her mother, she would not have been able to secure a legal termination in Northern Ireland or in England. In Northern Ireland, she would have to satisfy the Bourne test, but even had she done so, she couldn't possibly, without help, have navigated the medical system, given what we've seen, the response in cases like Sarah Ewart. And Mary Stopes, which provides terminations that satisfy the Bourne test under 9 weeks, they do not carry out medical terminations for children under 16. So even if she satisfied the test, she wouldn't have been able to access a termination legally. And we say it's arguable that she would satisfy the test. As for accessing a termination in England, she was a school child. She wasn't going to be able to leave school without explanation, without notice. She had no financial means of travelling to England without assistance. Even if she had, again, a 15-year-old child would not have the wherewithal and the resources to identify where to go in England, what to do, how to access money, and how to access the services she needed. And even if she did that, in England and Wales, as a matter of fact, BPS and other abortion providers don't provide abortions to those under 16 without being accompanied by an adult. So again, she cannot give effect to what would have been legal without support. Your lordships are familiar, obviously, with Article 3 of the United Nations Convention of the Child, and we say that the termination in this, that the mother in this case acted to secure her daughter's best interests and acted to give effect to her views in matters directly affecting her. in relation to bodily integrity and autonomy. We've referred your lordships to, and your ladyships to Article 12 of the UN Convention. We have enclosed the general comment number 12 on the right of the child to be heard, and I'll touch upon that if I have time. Article 12 is set out in our written case in MS 10407, and undoubtedly you're familiar. State parties shall ensure to the child who is capable of forming her own views the right to express those views freely. In all matters affecting the child, the views of the child should be given due weight in accordance with the age and maturity of the child. This child was clearly of an age to express and articulate her views. If I can urge at this stage you to look in due course at general comment number 12 on the right of the child to be heard. And we say that general comment number 12 is to Article 12, or general comment number 14 is to Article 3. It is and represents the authoritative guidance available to us as to the effect of Article 12, and we rely on Lord Carnwath's observations in SG and Lord Wilson's observations in Matheson, which have been previously referred to your lordships. If I could ask your lordships and ladyships in particular to look at paragraphs 1 and 2. Paragraph 1 reflects, not at this juncture, but paragraph 1 reflects the point we make about children's legal and social status undermining their ability to secure their autonomy. And Article 2 makes clear that, paragraph 2 makes clear that Article 12 is one of the 4 central principles of the United Nations Convention on the Rights of the Child, along with the right to life, the principle of non-discrimination, and the best interest principle. The right to be heard ranks as one of the 4 principles underpinning this convention, and therefore must inform us in our interpretation of convention rights. Interestingly, without referring to the United Nations Convention on the Rights of the Child, it's clear that concepts of the voice of the child were considered pertinent to the Article 3 question in the case of P&S versus Poland. And that authority, my lords, my ladies, will be found at Volume 3, Tab 20. Paragraph 166 is the paragraph I'll be referring you to. I don't again ask you to open it. And it's at MS 1137. But what the court said was, when deciding that in that case the Article 3 threshold had been met, the court concluded that no proper regard was had in that case to a child's vulnerability, and we say this was a vulnerable child, the young age of the child, and the other factor identified, her own views and feelings. So in the context of Article 3, looking at a child, the court considered it important to give weight in determining whether the threshold met to the fact that the child's own views had been that a termination was in her best interests. As we've indicated, she's inherently dependent on an adult to secure those rights. They also spoke about autonomy and the child's views in an Article 8 context, and again in the same judgment, MS 1126, paragraph 109. And in this case, they're distinguishing between the child and her parents. Legal guardianship cannot be considered to automatically confer on parents of a minor the right to take decisions concerning the minor's reproductive choices, because proper regard must be had to the minor's personal autonomy in this sphere. So again, it's a feature of reaching the threshold in relation to Article 3 or in relation to Article 8 engagement. The views of the child are important, even if they, as they didn't in this case, clash with the views of the parents. In the instant case, the child was entirely dependent on her mother to give effect to her voice. And we say what the law in Northern Ireland does is to compel and coerce a child to continue with an unwanted pregnancy. And they do so by virtue of a complete absence of support in relation to her choice by the state. We see when we look at what this child is faced with, if she says, I have a crisis pregnancy, I can't go to my parents, there is no support system. It is, to use the term and the language used yesterday, it is essentially a systemic failure on the part of the state. Doctors are reluctant to engage with women or girls. They're reluctant to engage in assessing whether the Bourne test is met, and therefore even those women or girls who would satisfy the Bourne test meet with barriers in terms of accessing pregnancy termination. More so a child, because certainly Mary Stopes, who are clearly going to be more open and supportive of a person in that particular position, have a policy of not carrying out terminations in relation to children. So she is in a particularly invidious position. The law essentially denies her access, even if she meets the Bourne criteria, denies her access on a systemic way to a termination in Northern Ireland. And when someone assists her, when someone helps her, they're punished, and they're punished by being prosecuted. They're punished in the first instance for going to their doctor, for going to their medical professions, because had they not done so, had they not dealt with their doctor in a transparent and open fashion, they wouldn't have been prosecuted. It was the fact that they were open and transparent in their dealings that created the difficulty.
We probably don't need to go into it, but the chilling effect arises from the fact that it occurs in any event, as this case shows. Information leaks, but what's the legal position regarding the doctors? Do they actually owe a duty in that situation?
Yes. It's something we have dealt with more fully in our submissions in the court below, but we would say, and in fact evidence was filed by the Humanists UK, medical evidence to say that the doctors were acting in breach of their duty of confidentiality.
They were in breach, so they didn't owe a duty to...
Yes, they did owe a duty to her.
They owed a duty to her, not a duty to the police.
No, there are circumstances in which they should provide information. It's not an absolute barrier. Medical confidentiality isn't an absolute barrier to disclosure. But in the normal course of events, you will at very minimum notify the person in question that you're going to disclose, and in the normal course of events, you will seek their consent. And if their consent isn't forthcoming, then there has to be a very, very powerful reason to provide it, and they would, in the normal course of events, have to justify. In this case, the child only became aware that her medical notes and records had been disclosed once they formed part of the prosecution papers for her mother. So nobody in the chain saw fit to disclose, not her doctor, not the counselling service, not social services or the police, nor the PPS, in fact. Right through the chain, public authorities really disregarded.
Yes, I mean, you say that's the sort of thing that happens and did happen in this case.
Yes, and of course, a chilling effect, a different chilling effect is the discouragement that we say that gives to women in this situation who take medical abortion pills online, who've done so illegally. If something happens, if there's a complication, do they then go back to their doctors, or does the message that this case, which has attracted significant publicity, say to women that you should lie to your doctor about the circumstances in which you come before them, which clearly we say, again, is a matter which has an adverse impact on women's health generally. We say their actions in this case will deter other parents from helping and supporting their children in circumstances where the state systemically does not help and support children in this situation. We say, my lords, that this is Article 3 ill treatment, and we say that if we're wrong about that, the factors amount to a significant and weighty interference with Article 8 rights, such that the balancing exercise doesn't weigh against the child's rights. In terms of the United Nations Convention on the Rights of the Child, if I could ask your lordships and ladyships, just in particular when you're looking at the general note, because we are really, in a very short form, urging you to consider the general comment in much the same way as you look at General Comment 14 in the context of Article 3. We would invite you to look in particular at Articles 1 and 2, and we would also, invite you to look at paragraph 98 onwards, which deals with the rights of the child in healthcare. And in the context, your lordships and ladyships will also be alive to the fact that Article 24 of the United Nations Convention on the Rights of the Child is relevant. It deals with access to healthcare. And in the context of Article 24, Article 24.1 states that the state parties recognise the right of the child to the enjoyment of the highest attainable standards of health. And in your Lordship's authorities bundle, Authorities Volume 18, it's tab 185, and it's MS page 6377. It's stated in the context of Article 24.1 that states should review and consider allowing children to consent to certain medical treatments and interventions without the permission of a parent, caregiver or guardian, such as HIV testing and sexual reproductive health services, including education and guidance on sexual health, contraception and safe abortion. And as has been indicated, the United Nations, the supervisory organisations have, in the context of children's rights, also talked about the need for access to safe abortion facilities and decriminalisation of abortion. My Lords, it's our case that the facts in our case are supportive of the position of the Northern Ireland Human Rights Commission, that the types of issues in this case do engage Article 3. We say they very clearly engage Article 3 in the context of the child that is before the court, and also in terms of the punishment of her mother by prosecution for doing what the state, for providing her with the help and support that the state was not prepared to provide. I think, my Lords, my Ladies, unless there's anything further, those are my submissions.
Thank you very much indeed, Ms Coonlevin. Thank you. Mr Hill.
My Lady, my Lords, in this matter, as you know, I appear for Christian Action Research and Education, ADF International UK, and Professor Patricia Casey. Our joint intervention, dated the 26th of September, can be found in Core Bundle Volume 5, Tab 17, MS 10885 and following. The material to which we make reference in our written submissions are in the authorities volumes 19, 20 and 21. It ranges from tab 197 to tab 218, although there are certain other matters interposed during that run of tabs. Of all the interveners who have been granted permission to make oral representations, we are the only ones who seek to uphold the decision of the Court of Appeal. And we also adopt the content of the written representations of the Northern Catholic bishops. For your note, that's a supplemental memory stick, page 53 and following, and the written submissions of the Society for the Protection of Unborn Children, which you have, I think, as a separate folder.
We have, because it only arrived yesterday.
I'm grateful.
But we had anticipated that the bishops would wish to make oral submissions as well, as they had done below, but they didn't wish to make oral submissions. So that's why you're on your own, Mr Hill. It's not for any decision of ours.
My Lady, I could hope I can make good any deficit their absence might have caused. My Lady, we contend as follows, that the law in Northern Ireland gives weight to the lives of unborn children. That is a reasonable, lawful and proportionate response, and it is within the ambit of discretion afforded by the European Convention on Human Rights. It has been consistently reaffirmed within the Northern Ireland Assembly, which is the appropriate decision for making issues such as this. It is, my Lady, to adopt your expression yesterday, part of the national psyche, as exemplified by the Grand Chamber decision in the Lautsi decision. Our intervention concerns three discrete matters, matters in which we say there was an evidential deficit in the lower courts. We have kept it brief, and it has been informed by the expertise of Professor Casey in relation to Part 3 and Professor John Wyatt in relation to Part 4. The draft has been prepared to reflect their expert opinion and their assessment of the clinical literature. Amnesty invite you to disregard our intervention on the procedural basis that there is no formal expert declaration. I can confirm that both Professor Casey and Professor Wyatt would be happy to supply such a declaration that can be filed this week if the court has any concerns in that regard. We only had sight of Amnesty's rebuttal evidence last night. We note that it rebuts not so much what we say, but what they recast as what we say. And I propose to say no more on that, save that the extent to which their evidence may differ from ours supports our primary contention that this matter is medically contentious and medically controversial, and certainly not as straightforward as the lower courts presumed it to be. Might I then move to the first point that we deal with, namely the value of Northern Ireland's abortion laws in the saving of lives, a matter which my Lord Mance raised yesterday afternoon during the course of submissions. Mr. Justice Horner, for your note MS 8857, remarked at paragraph 64, unfortunately there is an absence of any evidence to demonstrate whether the criminalisation of abortion in general and in respect to the categories under consideration in particular is effective in actually saving any prenatal life. We say that the first part of this evidential deficit has most assuredly been met. The figure of 100,000, which we rely on in our submissions as part of the Both Lives Matter submission, is a credible and conservative estimate. It has been independently verified and scrutinised by the Advertising Standards Agency, and you will find that at Authorities tab 218, MS 7544. To quote, on balance, we concluded that the evidence indicated there was a reasonable probability that around 100,000 people were alive in Northern Ireland today who would otherwise have been aborted had it been legal to do so. 7550, 7551. The ASA conclusion, after a robust stress testing of this estimate, is clear. The figures do not simply compare complete criminalisation as against abortion on demand. It asks the question whether the specific law in Northern Ireland has saved lives. It took into account and it made adjustments for factors such as the number of women who may have travelled to Great Britain for a termination, on which reliable figures were available from the Department of Health.
Doesn't the phrase saved lives beg a question? I mean, the statistics at most show that there were born from fetuses who would otherwise perhaps have been the subject of an abortion, children, lives. You can't say saved lives before birth, can you?
I think, my Lord, you are right, but the point remains that these are lives which have come to term and developed into human beings who would otherwise have been aborted had the Northern Irish law affected.
It doesn't avoid the fact that we're looking at the problem at the stage before birth.
Indeed you are, but as the first instance judge indicated, this was an area where statistics were not available. And they are now, at least that they are the best available conservative estimates that we have.
But how helpful are they in our assessment of the three particular categories which are the subject of the appeal?
They don't condescend into that level of detail, and that's something about which you have to form your own judgment. Mr. Justice Horner recognised the overall deficit and the specific deficit. What we've been able to do is to address the first.
Thank you.
Can I then move to the second of the three issues which we sought to deal with? Let me just say, but before moving on, it's said against us that figure may be controversial. Well, all I can say, ideologically it may be controversial, but statistically those figures have been examined by the Advertising Standards Agency, and as good as possible, they represent the figures that we have. The issue on psychiatric harm to women in crisis pregnancy. What we say on this is not in any way intended to diminish the genuine trauma suffered by Sarah Ewart and others, as is tellingly retold in their affidavits. What we do say on this is that the clinical literature suggests that abortion will not invariably and necessarily lead to mental health well-beings. One cannot extrapolate from the evidence of single instances into broad assertions such as Mr. Justice Horner purported to make. The material from Ferguson et al., Authorities Tab 205, MS 6994, citing the research studies of Coleman and others, find that abortion was associated in certain instances with increased rates of mental health problems. The principal findings of the analysis set out at MS 7000 was that there was no evidence for any outcome domain that the provision of abortion was associated with significant reductions in mental health. Further, the findings were consistent with all major reviews of this topic that have included either that abortion is unrelated to mental health outcomes, that abortion is associated with increases in risk of mental health outcomes, and that there is no review which has concluded that abortion has beneficial consequences by mitigating the mental health risks of unwanted pregnancy. The further report of Anne Gilchrist, the Authorities Tab 207, MS 7007, indicates that the rates of total reported psychiatric disorder were no higher after termination of pregnancy than after childbirth. And then moving on to 7008, one must bear in mind that this Gilchrist survey took a number of comparator groups, one of which included women who were refused abortion, and the Gilchrist conclusion at 7008 in the right-hand column is that there is no significant difference between the comparator groups, including those women who were refused abortion, in the overall rates of psychiatric illness. So in other words, looking at the generality of the medical evidence, rather than abortion invariably leading to psychological improvement or psychological well-being, termination of pregnancy for fetal abnormality is itself an emotionally traumatic major life event, which can lead to post-traumatic stress, intense grief reactions that are still detectable many years later. We cannot expect this court in its appellate capacity to resolve these complex and conflicting issues of medical expertise. The evidence we have tendered, the evidence tendered by others, points in certain directions. The evidence of Professor Casey includes both her own opinion and, in fairness, a survey of all available medical opinion known to her. What we say is that an abortion will not invariably eliminate the mother's suffering. The medical evidence is far more complex and far more nuanced than the lower courts were led to believe. Can I now, mindful of the time, move to the third substantive point we make in our written submissions, and that concerning the survival of those classified with so-called fetal abnormality. This was addressed by Mr. Justice Horner at paragraphs 148 and 160, MS 8885. In paragraph 148, he makes reference to a fetal abnormality making it incapable of existence independent of the mother's womb, and continues at 160 to say that when the fetus leaves the womb, it cannot survive independently. It is doomed. There is nothing to weigh in the balance. There is no human life to protect. And we say very clearly and without hesitation that assertion by Mr. Justice Horner is clearly wrong. It was not open to him to conclude that there is no life to protect following a diagnosis of so-called fetal abnormality. The talk in those and related paragraphs of the fetus actually poisoning the mother is, we say, as Professor Wyatt makes plain in our written submissions, wholly inappropriate in clinical terms. In the vast majority of instances in which an unborn child has a fetal abnormality, there is no risk to the mother's wife. This appeal was opened yesterday not with the language of fetal abnormality, which had commended itself to Mr. Justice Horner, but to serious fetal abnormality or to malformation of the fetus. And this terminology, we say, is much closer to the language of Section 11D of the Abortion Act of 1967. And I think it's important to bear in mind the executive summary of the first instance decision of Mr. Justice Horner at paragraph 1, Roman 5, and then at paragraph 1, Roman 6. Mr. Justice Horner rejects the Article 3 challenge in 4 specific cases: serious malformation of the fetus, fetal abnormality, pregnancies arising from rape, and pregnancies arising from incest. In paragraph 1, Roman 6, Mr. Justice Horner finds a breach only, and I emphasize the word only, by the absence of exceptions to the general prohibition in the cases of 1, fetal abnormality at any time, and 2, pregnancies arising from sexual crime up to the date when the fetus is capable of existing independently of the mother. So what the appellant is asking this court to do is to go significantly further than Mr. Justice Horner was prepared to go, without any solid clinical basis giving meaning or legal effect to the term serious malformation of the fetus. It would include the cleft palate, the club foot, and so on. And even if the appellant is less ambitious and seeks an exemption solely in relation to so-called fetal abnormality, attempting to define that concept, as Professor Wyatt makes plain in our written submissions, is both complex and artificial. Current medical practice refers to life-limiting conditions where there is no reasonable hope of cure and from which children will die. We refer to the Larcher clinical academic study, tab 209 for your note, MS 223. And we notice how the language has changed from the notice of appeal, where we speak of serious malformation of the fetus, to the terminology of fetal abnormality, which by definition is so much narrower. And this was, I think, Mr. Justice Horner's error in moving from the clearly tragic case of Sarah Ewart into a general proposition in respect of fetal abnormality, which he wrongly assumed could be infallibly recognized by clinicians, and which again he wrongly assumed referred to a fetus which could not have existence outside the womb. His expression of the term doomed simply is unsupported by any medical evidence. That there is a wide spectrum in the clinical literature of different clinical outcomes in relation to the life expectancies of children. Unborn children with severe conditions will often be born alive, and life expectancy can range from minutes to hours to weeks to months to years. And I would refer you to the Corrida paper at tab 202, MS 6790, and the Larcher paper at MS 7227.
This is a paper in the Archive of Diseases of Childhood, is it?
I think that's right, my lady, yes.
Yes. Well, it matters where these papers are published.
I had thought that was plain for the submissions. If it's not, forgive me.
Yeah. No, I was just looking at it. No.
What we say is this, that developments in palliative care have transformed the experience of parents whose children have life-limiting conditions, because it focuses on the enhancement of the quality of life for the child with support from the family. And we also note from the Department of Justice's April 2015 response paper, cited in part by Amnesty but not in full, for your note MS 10409, that doctors cannot predict how long a baby will survive is something which is acknowledged. And I quote, "It is accepted," this is paragraph 8.16, "it is accepted that the proposed clinical assessment at the point of diagnosis cannot predict with chronological accuracy the exact amount of time a baby may live if born with a fatal condition. The assessment does not ask for this, as it can never be given." So what the appellant is inviting this court to do is to impugn a law on the basis that it fails to provide an exception, the boundary of which is impossible to define by them as a matter of law, and by the medical profession as a matter of consistent clinical judgment.
Mr. Hill, you've referred to paragraph 8.16 of that document. Of course, 8.14 of the document says, while acknowledging medical diagnosis can't be flawless, the evidence presented to the consultation by all the medical bodies points to a high degree of accuracy in diagnosing fetal anomalies. I think you challenge that, don't you?
Yes, because a fetal anomaly covers a vast range of possibilities, none of which can give with any certainty the prospect of what Mr. Justice Horner categorized as a doomed fetus. And that notwithstanding an anomaly, the fetus can come to full term, be born alive, and have a meaningful life of a duration which is at present unknown. The medical evidence such as we have isn't sufficient to answer the fundamental question which the appellants are seeking to put before the court. Well, I must bring matters briefly to a close. The present law preserves the lives of unborn children without discriminating on the basis of their health or their disability, or on any subjective assessment of the quality and duration of their time outside the womb, enjoying the very highest standards of palliative care. We say that these proceedings in many ways have developed a momentum of their own on a factual misunderstanding which is now even more porous than it was at first instance. That there are serious matters here which touch at the very heart of human existence. This is much more serious than casual conversation of acorns, chickens, and eggs. To borrow, if I may, from the Quaker poet John Greenleaf Whittier, the concern of those interveners, whom I have the privilege of representing this morning, is that somehow, amongst the earthquake, wind and fire of the litigation, the court may yet hear the still small voice of the unborn child.
Ladies and my lords, I've provided my speaking note. I think you all have it in front.
You have indeed, but could I please ask you to speak up?
I certainly will do that.
These microphones hardly do any amplification at all.
Thank you.
The important thing is that we hear what you have to say.
Correct. Of course it is. Then I will speak up. So you have the speaking note. I'm very conscious of time, and I will email that round to my colleagues. I didn't have an opportunity to do it. My ladies and my lords, we had permission to intervene on the 2nd of October 2017 to respond to the evidence submitted by the 5th interveners. Collectively, we refer to them as CARE, and we received their submissions on the 5th of October. And in the short time available, we've been able to obtain some further evidence to respond, and that's namely in the form of 2 affidavits. One from Professor Dornan, Emeritus Professor in Maternal and Fetal Medicine at Queen's University Belfast, who's also Professor of Health and Life Sciences at Ulster University, and that's in Supplemental MS 95, and Denise Phelan, Supplemental MS 105. Our application for leave to adduce them is at Supplemental MS 81. Extracts from Denise Phelan's affidavit have already been read to the court and relied on by Ms. Levin, and we formally seek leave now to adduce them. Our written submissions are at Core Bundle 5, MS 10445 and onwards, and they, of course, don't refer to that evidence, and we ask that you read the affidavits in their entirety, as I've only really got time now to sort of highlight some of the points. And in fact, there are also some things that Mr. Hill said that I'm going to try and respond to, and that's part of the benefit of giving you the speaking note in case time does not permit me to get all the way through. I'm going to deal with really the 3 main points that he identified. One is that the 100,000 more people alive. That's at section 2 of the submission, Core Volume 5, MS 10887. CARE notes there that a report by Both Lives Matters, as you heard, estimated that around 100,000 people are alive in Northern Ireland today due to the decision 50 years ago not to introduce the Abortion Act. This was supposedly to respond to Mr. Justice Horner's comment at paragraph 64, MS 8857, that neither the department nor the attorney had provided the figures to enable him to see how many Northern Ireland Down syndrome and spina bifida fetuses were being aborted in England. If one goes to the judgment, you see that that's actually what he was concerned with at that time, and it came in the context of the UN Convention in relation to the rights of the child, of people with disabilities. This 100,000 figure, my ladies and my lords, is not the answer. Ms. Levin explained it doesn't appear to be focused on the present day when many women obtain abortions despite the prohibition, and that those figures simply can't be known. And Ms. Levin said that, for example, if her clients had never gone to the GP, never disclosed how the fetus was aborted, that figure would simply not be in the records. So that there is no way of knowing how many, even now, are being aborted. And as Lady Hale noted, this case is actually not about the 67 Act, but it's about 3 very specific instances that are being appealed in relation to, and the number of women who seek abortion in that narrow category is a tiny proportion of those who seek abortion for all other reasons. See, for example, the authority bundle 19, MS 6560 and 6617. And of course, it's evident that the fetus with an FFA diagnosis would not be capable of independent life in any event, irrespective of where it's conceived and where that happens. So of the remaining women in this narrow category, namely those who have suffered rape or incest, most, if not all, will obtain an abortion under the law as it is now, and they're likely to be highly motivated to take abortifacient drugs. And the JR76 is simply an example of that. And in fact, we say that the narrow change in the law that is sought actually has the potential to save life. Paragraph 29 of his affidavit, supplemental MS 103, Professor Dornan explains how in an FFA pregnancy, the carry-on until the fetus dies approach is associated with an increased risk of mortality to the woman, and the death of a fetus in utero can not only cause sepsis or infertility, but actually can kill. And international human rights bodies and experts, such as the World Health Organization, agree. If CR submissions paragraph 32 MS 10455. By contrast, expert evidence shows medical abortion is effective and safe. MS 10488. In fact, that is actually one of the prime reasons of the move for decriminalisation and greater liberalisation, because it is effective and it is safe. And what CARE has adduced in terms of these numbers really doesn't address the specific issues at hand and doesn't help. So the second point then is the no difference in mental health outcome. CARE claims that mental health problems are no higher in those who have been denied an abortion than those who've had abortions, and you've heard Mr. Hill on that. That's said at Core Volume 5, MS 10891. And then in my respectful submission, he gets Ferguson wrong. And one can see that from our submissions, paragraph 86, MS 10471. And it's worth just looking at that very quickly. The Ferguson article accepts it does not address the comparison between those having abortions and those refused abortions. And it acknowledges that a separate study into that question concluded that for reasons of outcomes, psychotic illnesses, non-psychotic illnesses, self-harm, those refused abortion fared worse than those provided with an abortion. And in fact, there is a longitudinal study, which is precisely the sort of study you want to do to make those comparisons, and we refer to that study at paragraph 85 of our submissions, MS 10471, and that study reported in January of this year, and what it found was that women who were denied an abortion reported significantly more anxiety symptoms and lower self-esteem and life satisfaction. And women with a history of mental health conditions are at a greater risk of experiencing adverse outcomes and may have poorer health outcomes if they are denied an abortion than if they receive a wanted an abortion. Of course, Denise Phelan is precisely an example of that. So we say, my ladies and my lords, that there is substantial evidence to show that the criminalisation of abortion in the categories at issue in this case can cause serious mental suffering. And we refer you to our submissions at paragraph 27 to 54, Core Volume 5, MS 10454, and they in turn refer at paragraphs 32, 43 and 52 to the reports of the international human rights bodies and experts, including the UN Human Rights Committee, the UN Committee on Torture, and the UN Special Rapporteur on Torture. Well, that's all the figures out of the way. What about the actual people whose evidence, my ladies and my lords, one has before you? It caused Sarah Hewitt intense and long-lasting mental distress. She was denied an abortion in Northern Ireland and subsequently had one in England. And she explains how the practical consequences of the criminal prohibition on abortion were devastating and at times almost overwhelming. MS 9398, paragraphs 1357. And that wasn't just limited to the length of her pregnancy. It wasn't all done when she succeeded in obtaining an abortion. To the contrary, In January 2016, she said, "I feel that for nearly 3 years now, I've been caught up in a nightmare." And she says that at MS 93-94 at paragraph 19. And the reason for that was that she was denied crucial information about how to have an abortion and assistance in transferring her medical history to those treating her because of fears of criminal prosecution. And that's at paragraph 24-26 of MS 93-96. And the law challenged also prevented her, and this is critical, from obtaining an autopsy. She was told by her consultant that she's at high risk of a recurrence, MS 94-99. However, consultant pediatric pathologist Dr. Gannon explains that without an autopsy, it's not possible to accurately assess that risk or the extent, worse yet, almost, to which her younger sister is also at risk, MS 104-79. And Dr. Gannon notes it's unclear to medical professionals in Northern Ireland whether performing an autopsy on an aborted fetus contravenes the prohibition. They didn't even know whether they could do that to help her. And that is not something that can be put right for Sarah Hewitt now. She's been left in a permanent state of uncertainty. The time to put that right and to inform her and her younger sister was when they had the fetal remains. They don't have them anymore. They won't have that information. Denise Phelan is another graphic illustration of the serious and long-term adverse effect that the prohibition on abortion may have on a woman. Her baby was diagnosed with fatal abnormality. She had a prior diagnosis of clinical depression and psychosis and was at risk of developing psychosis again. Yet she was not permitted to have an abortion. She was told by 2 psychiatrists that they could not envisage any circumstances in which a woman in Northern Ireland would be considered to meet the Bourne test on the basis of risk to mental health. That's at supplemental MS 110. Miss Phelan was unable to travel to have an abortion due to her ill health, so somebody like her wouldn't benefit from the recent changes that have been made. Her baby died inside her at 36 weeks, and 5 days later she endured an induced birth of the fetus corpse, which by that stage had begun to decay. And she describes the effect. And it's worth actually just having her words, supplemental MS 113. "I know that there are some who think that it's somehow better for a pregnant woman to have the opportunity to give birth to her baby that has been diagnosed with a fatal fetal abnormality, to have the chance to hold it and say goodbye. Well, whilst there are some who wish to do that, that cannot be assumed to be the case for everyone. People who argue that a woman should be deprived of choice and forced to undergo the horrific birth cannot have experienced the anguish that I and others like me felt in having to have an induced labour to give birth to a baby that is dead, severely malformed, and partially decomposed. It is an experience I know I cannot adequately describe, but it's seared in my mind, and I will never excise it." And then she goes on, "This entire experience has had a detrimental impact on my husband and my family life. As a result of the government's interference, given what we have both been through, we have had to take a decision not to have a family." That's lifelong effect. If we had stayed in England, we would have been able to have a termination at 20 weeks and we could have gone on to try for another baby. But we live under this barbaric regime, and I was not prepared to keep suffering. At one point, we thought about adopting children, but the reality is that our lives have been so destroyed and our relationship is not one into which it would be fair to bring a child. We struggle to cope with life after what has happened to us, and we have nothing left to give to a child. And the reference to that is MS 114. So these cases and other cases and evidence before the court demonstrate that the criminalisation of abortion in this context may cause severe psychological distress. And I'm conscious of the time, and I just want to go perhaps briefly to the fatal fetal abnormality point, which is really a diagnostic issue. And what CARE says at section 4 is that attempting to distinguish between concepts of serious or fatal fetal abnormality is complex and artificial, MS 108-94. The submission appears to be relevant to the question of whether there is a feasible and robust system which could be used to affect the exception to the prohibition on abortion that the Commission seeks. And from paragraph 70 onwards of our written submission, we contend that there plainly is. That's MS 104-65.
Well, I think you can probably dispense with the MS numbers because
I'm very grateful. I'm very grateful that saves a few seconds. That is in part because clinicians can determine with sufficient reliability which cases involve severe or fatal abnormality. Now, Mr. Justice Horner said that the doctors know when a fetus has an FFA. This is primarily a medical diagnosis, not a legal judgment, and in those circumstances, the doctor can be reasonably certain that the fetus will be unable to live independently outside the womb. And we say he was entitled to make that finding. And my Lord Mance has already referred to the 2015 consultation document and the high degree of accuracy in diagnosing fetal anomalies. And that, of course, is something that Ms. Leven referred to yesterday, the clinician's expertise in doing that in relation to the 67 Act at 11D. The medical organisations who supported that conclusion included essentially all the important medical professional bodies. And Professor Dornan, whose evidence we have tendered, agrees. He is a foremost expert in this field, certainly one of the most qualified in this field in Northern Ireland. You can see his qualifications and experience, and he explains that clinicians in Northern Ireland can diagnose with a high degree of accuracy whether a fetus is likely to die. And he says at paragraph 20, and this point is worth noting, if, as indicated by the department in its consultation, the objective of the diagnosis is to identify those fetuses with a condition that is incompatible with life, whether in the sense that it's unlikely to be able to continue to term or survive the birth process, or to be able to maintain its vital functions independently for anything more than a few days, if that's what the objective is, then that is a matter that clinicians are well able to accurately diagnose antenatally. If, for example, a fetus doesn't have a brain, as is the case with some that are diagnosed with anencephaly, then clinicians are well able to provide the pregnant woman with a prognosis that the fetus is simply not going to be able to survive. So we say that CARE's submissions provides no basis for departing from Mr. Justice Horner. And then they go on to say that they assume that if a fetus is diagnosed with a particular condition, such as trisomy 13 or 18 or spina bifida, then that will automatically lead to the conclusion that the fetus is incapable of life outside the womb. And we say that that assumption is incorrect. And Professor Dornan, if one looks at his affidavit, explains the conclusion as to whether a fetus is capable of independent life is not made merely on the basis of a particular condition. Clinicians do not approach matters so simplistically. They assess the particular fetus before them and consider the relevant factors. And that's at his paragraph 27. And he rejects the assertion that the term that CARE make, that the term fatal fetal abnormality risks becoming a self-fulfilling prophecy affecting the information and treatment that is given. And I think it's worth looking at why he says that is unlikely to, would not be the case. And you have the reference there, paragraph 4.19. So then just very finally, we, in our written submissions, apart from dealing with those matters, we deal with a few other matters, and I'm only going to identify them now so that your ladyships and lordships can look at them in our submission. We submit that the principal test for standing under section 71(2)(b)(c), when read properly and in context, is to ask whether there would be a victim for the purpose of Article 34 of the ECHR, and we submit that Sarah Ewart is a victim for those purposes, and the Commission has standing to bring this claim. And we set out why, on that limb, and we set out why the legislation is incompatible with Articles 3, 8 and 14, having regard to the particular facts of Sarah Ewart's case and the background material provided by Amnesty. And we say that having regard to the circumstances of Sarah Ewart and those like her, and having regard to the factors mentioned in Nicholson, it is appropriate for the Supreme Court to determine whether the legislation is compatible with the Convention. And we also submit that sections 58 and 59 Offences Against a Person Act and the section 25 Criminal Justice Act can be read and given effect such that it's lawful to bring about or procure abortion in cases of fatal fetal abnormality, rape and incest. And we in fact had written submissions at both levels of this case on that very point. And then to conclude, Ms. Leven sought to anticipate the Attorney General arguing that we have selected the hardest cases have been selected. And I think she might have accepted that, but we don't accept that. We don't think that there's any evidence before the court here that these cases are exceptional. They are difficult to read and hear, but that doesn't distract from the fact that they are representative. And that can be seen from the cases in Amnesty International's report of 2015, the evidence of Dawn Purvis, of Mara Clark, and the cases of Amanda Mellett and Siobhan Whelan. In fact, there is a very, very striking similarity in the impact on all those women of this form of criminalisation. There's just one matter I wanted to actually help I think it was Lord Mance, who asked about, Lord Mance, you asked Miss Quinlivan, no, sorry, it was Lord Wilson, he asked Miss Quinlivan whether there was any reason why the doctors would disclose the information and whether it breached their duties in any way. Well, the answer to that can be found, or why they might have done it.
I think it was me.
Sorry?
It was I.
Oh, it was. Thank you. Well, I'm glad I got that one right. Well, the answer to that can be found in the 2016 guide. I'll just give the reference because I'm conscious I'm trespassing on somebody else's time. It's at MS 9824, and in that guide there's a whole section devoted to requirements for disclosure of information, and it tells the clinicians under no uncertain terms that if they consider there's been an unlawful termination of pregnancy, then they have a duty under the Criminal Law Act 9167 to give that information to the police. And that is actually one of the issues in JR 76, where I also represent interveners. Thank you very much indeed.
Thank you very much indeed, Mrs. Anya Dyke-Dyens. Thank you. Now. So welcome, Mr. Chamberlain. We were expecting to hear from the attorney at this stage.
My ladies, my lords, I'm going to deal at the outset with Article 3 on behalf of the attorney, and the attorney will himself then deal with Article 8 and Article 14.
Thank you.
On Article 3, I'd like to make submissions under 6 heads. First, the Northern Ireland law governing abortion reflects a deliberate democratic judgment made as recently as last year about the value to be ascribed to unborn human life and about the proper way to balance the autonomy interests of women against the fetus's interest in life. Second, the importance of maintaining that balance in the law of Northern Ireland is not diminished by the availability of abortions in other parts of the United Kingdom or elsewhere in the European Union. But the availability of funded abortions in England and Wales, together with funding for travel, is relevant when assessing whether the existence of the law gives rise to a violation of Article 3, or, for that matter, 8 or 14. Third, the decisions of the House of Lords and the Strasbourg Court in the Pretty case make clear that challenges to substantive domestic law in cases such as this engage the qualified positive obligation under Article 3 and not the unqualified negative obligation not to inflict torture or inhuman or degrading treatment. And cases such as Gefgen and Ireland against the UK are therefore not on point. Fourth, and relatedly, in determining whether treatment is inhuman or degrading, the Strasbourg Court focuses not purely on the extent of the applicant's suffering, but also on the moral characterization of any act on the part of state agents that inflicts it. The Polish cases concerned failures to provide to the applicants services to which they were entitled under domestic law. In those cases, there was at the very least an arguable basis for stigmatizing the conduct of medical and other state agents as shabby or callous or debasing or humiliating. in other words, as morally blameworthy. Fifth, there is by contrast a profound difficulty with ascribing that kind of moral opprobrium to a law which reflects a principled democratic balance between two undoubtedly important human interests. That is why the Strasbourg Court has never found a violation of Article 3 in a case where the applicant has been denied an abortion because of a substantive legal prohibition imposed in order to protect the interests of the unborn. Sixth, the international materials do not affect the analysis. The Neulinger principle upon which Ms. Leven relies requires the Convention to be interpreted in a way that avoids putting states under conflicting international law obligations. It does not require that the Convention must always be given the same interpretation as other instruments covering similar topics. In any event, the views of the CEDAW and Human Rights Committees about Ireland's abortion law were known to the Grand Chamber in A, B and C, yet it still held that Ireland's more stringent legal prohibition did not even arguably give rise to a violation of Article 3 in those cases. And the views of the Committee on the Rights of Persons with Disabilities tells against any exception for cases of fetal abnormality. Can I turn then to my first heading, which is that the law reflects a balance between the woman's autonomy interest and the fetus's own interest. It was submitted yesterday by Miss Rose that the law in Northern Ireland accords no weight to the autonomy interests of women. That is, with respect, wrong. Almost every country in the world has a law, backed by criminal sanction, governing the circumstances in which abortion is lawful. The task of setting out those circumstances generally involves a balancing of the interests of the woman in personal autonomy and the interests of the unborn child. I've used the word interest deliberately so as not to make any question-begging assumptions of the kind Lord Mance deprecated in argument about when an interest achieves the necessary moral or legal backing to become a right. The process of balancing these interests necessarily means that in some circumstances one interest will outweigh the other. Deciding when the interests of the fetus will outweigh the interests of the woman necessarily involves taking a view on two issues. First, from what point and subject to what conditions does a fetus have an interest that the law should protect? Some laws, like Germany's, refuse to accord any weight to the interests of the fetus until it reaches a particular stage in its gestation. Others, by contrast, accord weight to the interests of the fetus from the moment of conception. Some laws, like that applicable in Great Britain, accord lesser protection to the interests of a fetus that has a disability or abnormality. Others do not differentiate in that way. These are matters on which different legislatures representing different polities may legitimately differ. The second matter that a legislature has to consider in deciding how to strike the balance is how much weight to ascribe to the interests of the fetus. This too is a matter on which different legislatures and polities can legitimately differ. There is nothing wrong in principle with a law that gives precedence to the interests of the woman only where a medical judgment has been made about the effect of continuing with the pregnancy on her life or health. That is, of course, precisely what the Abortion Act 1967 does in Great Britain. In Northern Ireland, the law reflects a moral judgment, first, that the interests of the unborn are in principle entitled to protection from the point of conception and irrespective of disability. Second, that the fetus has protectable interests irrespective of the circumstances of its conception. And third, that these interests are so important that they outweigh the autonomy interest of the mother, save where continuing with the pregnancy poses a possible risk to the life of the mother or a probable risk of a serious and long-term adverse effect on her health. Now, what I've done there, I hope not inaccurately, is to reduce to a sentence the guidance which was given by Mr. Justice Kerr, as he then was, and then approved by Lord Justice Shield. It's set out in a series of bullet points in paragraph 6 of our case. The balance struck by the current law in Northern Ireland is not dictated by a law that has lain unexamined for years. It's the result of deliberate, informed, democratic debate and decision, as recently as last year, 2016. The question whether to amend the existing law was the subject of a thorough recent public consultation. That was in 2015. And then in February 2016, following Mr. Justice Horner's judgment in this case, a debate in the Northern Ireland legislature. And it's important to recall that the legislature considered and rejected proposals to create exceptions to the existing law in cases of sexual crime and in cases of fatal fetal abnormality. In other words, exceptions directed almost precisely to Ms. Leaven's 3 categories.
But didn't it all go off to a working party?
Well, certainly one aspect, the aspect of fatal fetal abnormality, there was an intention indeed for that to go off to a working party. But that itself is a legislative choice which is entitled to respect in this court. And we are talking here about a judgment that was made only just over a year ago. So it would be a strong thing for this court to say, as some members of the court in, for example, Nicklinson were minded to say, well, it's about time that we did something because Parliament hasn't. This is, as I've said, a consideration that took place last year. And it would be a strong thing for the court to intervene in those circumstances.
And what's the working party said about this?
Well, the difficulty, as you know, of course there's been a difficulty because the political situation in Northern Ireland there is a hiatus, as it were, in the political situation in Northern Ireland and has been since the beginning of this year. Now that is obviously a political fact which creates difficulties, but it's not a fact which is such as ultimately to change the degree of respect that is still owed to the views of the legislature expressed last year.
I think my question was, what's the working party said about this?
Well, I think the answer to that is that it hasn't been published yet.
It said something, but it hasn't been published.
It hasn't published its report yet.
Is it under the same stalemate as the politicians?
I understand that its view has been formulated and it is awaiting consideration by ministers.
Well, has it prepared its report?
It's prepared its report, but the report has not been published, as I understand it. So that's where we are on the questions.
But there are other ministers to consider it at the moment?
No, not yet.
No.
For the political stalemate reasons that
That's what I thought, yes.
know about since the beginning of this year.
Yes.
Ladies and lords, the fact that a law has a democratic imprimatur doesn't, of course, insulate it from challenge under the Convention, but it does form a vital part of the background against which any such challenge falls to be judged, both as respects Article 8 and as respects Article 3. So does the fact that the law reflects deeply held ethical and religious positions about the value to be attached to unborn human life and the proper way to balance that value against a woman's right to autonomy. Now, it was suggested yesterday, and this is my second head, by Ms. Leven, that the availability of funded abortion elsewhere in the United Kingdom, together with assistance with travel costs to get there, means that it is incoherent for the Northern Ireland legislature or for Northern Ireland to justify its law on the basis of the protection of the life of the unborn. We would respond as follows. As Lord Reid suggested in argument, that submission would have potentially very wide implications. He gave one example of how the argument might be applied. Another obvious one might be the case of assisted dying. Now, it's well known that there are other countries around the world where people from the UK can and do go to end their lives. Switzerland is one. But the fact that some people may choose to travel to Switzerland to end their lives does not make it in principle incoherent for the United Kingdom to refuse to permit assisted dying here. If it did, the concept of a margin of appreciation in areas such as this would be swiftly undermined, because whenever a Council of Europe state chose to permit something that would deprive others of arguments admissible under the Convention, that would deprive others of arguments admissible under the Convention to justify their own criminal law prohibitions. And a similar point can be made about divergences between laws as between the devolved legislatures within the United Kingdom. The majority of this court in A's case, of course, earlier this year, held that it was legitimate for the Secretary of State not to pay for abortion for Northern Ireland women, so as to respect the democratic choice of the people of Northern Ireland. It would be an odd result if the decision to reverse that by the government in England and Wales, the United Kingdom government, led in this court to the overturning of that democratic choice. Now, we absolutely accept that vulnerable women who wish to travel for abortions in England and Wales are likely to be subject to additional stress because of that. But the fact that funded abortion is now available for women from Northern Ireland in England and Wales is relevant when assessing the effect of the challenged law in terms of Article 3 and in terms of Article 8. That much can be seen from the judgment in A, B and C, where one of the pressures operating on women, recognised by the court, was a financial one. That pressure, together with other stresses operating on very vulnerable women, was not enough to raise even an arguable case that Article 3 had been violated. Here, one pressure at least, the financial one, has been addressed. Can I move now to my third head of submissions, which is the concept of treatment and the distinction between the negative and positive obligations imposed by Article 3. Now, there is, as the court knows, a dispute between the parties about the relevance of the case law on prohibitions on assisted suicide. The Commission says that's a very different topic because there's no international consensus on whether, and if so when, the state should permit assisted suicide. We accept that there are some differences in terms of the degree of consensus, a topic that I'll have something to say about when we come to look at the international materials. But one key similarity between the right to die cases and the present situation is that both involve claims that Article 3 is violated by the application of a principled substantive legal prohibition. And that makes the decision, we say, of the House of Lords in the Pretty case highly relevant. Now, Pretty is in Authorities Bundle 9, tab 82, MS 3196. Pretty is a case in which, on any view, the level of severity of the claimant's actual and apprehended suffering was very high. So Lord Bingham opened his judgment in that case. You see this at 3211, MS 3211. 3205 is the beginning. By saying that she faced the prospect of a humiliating and distressing death. Her case on Article 3 was summarised at paragraph 11 in this way. This is at 3210. You can see that the steps are set out in numbered propositions in that paragraph. Essentially, she said that by denying her the only effective means to alleviate her suffering, the state was subjecting her to inhuman and degrading treatment. So there's a very close analogy with the argument that's being made here. Then at 14, Lord Bingham notes that the authority most helpful to Mrs. Pretty is D in the United Kingdom, which was a medical treatment case where the United Kingdom was said to have breached Article 3 by removing a man in the later stages of AIDS to St. Kitts, where there was no adequate treatment. Lord Bingham said that there might be an analogy if a public official had denied Mrs. Pretty pain-killing or palliative drugs, but the refusal to give an assurance that she would not be prosecuted could not constitute treatment so as to engage the negative prohibition in Article 3. And then at 15, over the page, you can see Lord Bingham explaining that, if anything, what was engaged was the positive obligation to take action to prevent the subjection of individuals to proscribed ill treatment, but this obligation was not absolute and not unqualified. And that meant, see over the page at 3213, that while states may be absolutely forbidden to inflict the proscribed ill treatment on individuals within their jurisdictions, the steps appropriate or necessary to discharge a positive obligation will be more judgmental, more prone to variation from state to state, more dependent on the opinions of the people, and less susceptible to any universal injunction. Now, exactly the same analysis can be found in the judgment of the Strasbourg Court, which is in Authorities Bundle 4, tab 21, MS 1142. And I'll just give you the references, but...
Which bundle was it again?
I'm sorry, Bundle 4, tab 21, MS 1142. At paragraphs 50 to 54, which is MS 1173 to 4, it rejected the submission that the suffering which Mrs. Pretty was enduring and would endure could be regarded as inflicted by the state because of the criminalisation of the actions she wished to take to alleviate it. And at 55, it rejected the submission that the Article 3 positive obligation imposed a duty to sanction actions intended to terminate life. So those were the words it used at paragraph 55.
By sanction, it meant permit,
yes,
rather than punish. It's always been such a difficult word, sanction.
Yes. Well,
it's two diametrically opposed meanings.
Yes, indeed. The suggestion was clearly that Article 3, the suggestion made by the claimant was clearly that Article 3 imposed the duty to permit actions intended to terminate life, and that was the suggestion that the court resoundingly rejected. Now, assisted suicide and abortion are obviously not the same issue, but the structure of the analysis in Pretty is, we submit, plainly applicable here. That is because, as in Pretty, the first cause of the individual's suffering is not the acts of state agents, but a factual situation out with the state's control. As in Pretty, the factor said to engage the responsibility of the state is the existence of a criminal prohibition which prevents the individual from alleviating or mitigating her suffering. If the House of Lords and Strasbourg Court were correct to analyse the situation in Pretty as engaging the positive obligation under Article 3 and not the negative one, the same must be true here. Finally, the conclusion that the Article 3 positive obligation cannot impose a duty to sanction, permit, if you like, actions intended to terminate life is as applicable here as it is in the context of assisted dying. Now, Ms. Leven seeks to avoid that point by saying that it rests on the assumption that the fetus has a right to life under Article 2. But it does not rest on any such assumption. It is not necessary to posit that an unborn child has a right to life, to allow that he or she has a life that is valuable and deserving of protection. And it follows that whatever else an abortion is, and whatever view one takes about whether and when it should be permitted, it is certainly an act intended to terminate life. That point, or rather the point that it's not necessary to assume that the fetus has a right to life, for it nonetheless to have an interest that is deserving of protection, is made by the Strasbourg court in Vaux and France. I'm not going to ask you to turn it up, but I'll give you the reference. It's Authorities Bundle 4, tab 26, MS 1370-1 at paragraph 84. Now, Lord Mance asked Ms. Leven yesterday whether the statutory prohibitions at issue here could themselves be prayed in aid as evidencing a moral view equivalent to that reflected in the Constitution, for example, of the Republic of Ireland. We say the answer is yes, they can. Obviously, we have no codified constitution. We do have, of course, in Northern Ireland, the Northern Ireland Act, which has been referred to by this court, by the House of Lords, as effectively the Constitution of Northern Ireland. And that Act confers on the legislature the power to express the views of the people of Northern Ireland. And that is, we say, what happened last year. Once the Article 3 challenge in this case is properly understood as structurally equivalent to the Article 3 challenge in the right to die cases, Ms. Leven's reliance on the unqualified nature of the negative obligation under Article 3 falls away. So cases like Gefgen, and you'll recall the analogy that Ms. Leven made yesterday with the live child, the 9 or 10-year-old child, whose interest was not such that it was permissible to even threaten torture, are simply not in point at all, because those are cases that are concerned with the negative obligation in Article 3, not to inflict torture or inhuman or degrading treatment. That obligation is absolute and cannot ever be derogated from. This case is not about that obligation. It's about what state steps it is reasonable for the state to have to take to alleviate or mitigate real and acknowledged suffering, first caused by factors outside its control. And that is, as Lord Bingham said, a qualified or judgmental question, not an absolute one. And once you allow that the obligation is qualified, it immediately becomes highly relevant to the Article 3 analysis as to the Article 8 analysis, that the prohibition that we're dealing with has been the subject of extensive public consultation and recent debate in the legislature, addressed to the very categories of case now the subject of this challenge. Compare, in this respect, the weight given by the Grand Chamber in A, B, and C to the public reflection which had taken place in Ireland. That's dealt with at paragraph 225 of the judgment in A, B, and C, Authorities Bundle 3, tab 13, MS 784. And it also brings into play Lord Bingham's observation in the Countryside Alliance case, Authorities Bundle 1, tab 6, MS 349, paragraph 45, that the democratic process is liable to be subverted if, on a question of moral and political judgment, opponents of the Act achieve through the courts what they could not achieve in Parliament. That is precisely what the opponents of the Act are trying to achieve in these proceedings. Can I move to my fourth head? And I hope to do it relatively quickly, because much of the material here is in our case. And that is this, that in determining whether treatment is inhuman or degrading, the Strasbourg court focuses not just on the extent of the applicant's suffering, but also, and critically, on the moral characterization of any act on the part of the state that inflicts it. Now, I was going to go to the case, the first of the Polish cases, which is the case of Tysiąc at Authorities Bundle 4, tab 25, MS 1297. But I think in view of the time, I'll go straight to the next one, which is RR, which is, of course, the first of the cases where an Article 3 breach was held by the majority of the court. This was, of course, a case, as was Tysiąc as well, where the applicant was denied an abortion in circumstances where domestic law entitled her to one. And if one looks at that case, it's in Authorities Bundle 4, also tab 22, taking it up at paragraph 149 on MS 1218. The court sets out the relevant principles for determining whether something can be an Article 3 breach. At 151, one can see that the purpose of the treatment is to be taken into account, but an intention to humiliate or debase is not necessary for a finding of Article 3. And then it referred also to the case law on enforced disappearances, where failures to deal with requests for information from relatives have given rise to violations of Article 3 if they disclose, and these words we say are important, a callous disregard for their vulnerability and distress. Then one sees the formulation that you've already seen before. The court recalls that acts and omissions in the field of healthcare policy can engage Article 3 by a failure to provide appropriate medical treatment. I think this may have been remarked upon before, but if one looks at the footnote to that, the footnote is a case called Powell in the United Kingdom, which actually involved no allegation of breach of Article 3 at all. Yep. Of course, there are cases, as Lord Bingham said in the Pretty case, where failures to provide medical treatment have led to findings of a violation of Article 3. That's cases like D against the United Kingdom, the St Kitts case, but those are very, that is a very narrow category of case and applies only when someone has been receiving a particular form of medical treatment, is nearing the end of his or her life, and then is subject to removal. Then at 154 and following, you see the facts of the case, the importance of timely genetic testing to which the claimant, or the applicant, was entitled under Polish law, the fact that this was not done, the fact that it was not done not because of a lack of resources, but because of failures by the medical professionals. And that was the context then at 158 for the finding that there was no indication that the legal obligations of the relevant medical professionals were ever taken into account by those professionals. And then at 159, there's the obligation that the applicant, like any women in her situation, would be likely to be deeply distressed by the information that the fetus might be affected with a malformation. Now that was relevant not because the court was saying that Article 3 confers a right to abortion in cases of fetal abnormality, but because it explained why it was important that she receive the testing to which domestic law entitled her. So at 160, the court concludes that her suffering was aggravated by the fact that the diagnostic services she'd requested were at all times available, and she was entitled to them under domestic law. And it's important also to read this case with the dissent, or rather the separate opinion of Judge Bratzer in mind. You can see at 1238 his view that actually these facts didn't amount to a violation of Article 3, but he agreed that there had been a violation of Article 8. Well, the facts and the question whether there was a violation in that case doesn't matter, because the context of that case was plainly that the applicant had been shabbily treated, as the court said at paragraph 160, by medical professionals in her country, and that is what, in the view of the majority, justified the finding of a breach of Article 3. The next case, which I can give you the references to, but won't go to in view of the time, is P&S. And that's another case which shows the Strasbourg Court's focus on the moral characterization of the act or acts that inflict the treatment complained of. Now, of course, it's right that in that case the applicant was in a situation of great vulnerability because she was 14 and she'd been raped. But it wasn't those facts, but rather a litany of callous conduct on the part of the authorities that justified the finding at paragraph 168, MS 1137, that she'd been treated in a, quote, deplorable manner. Now, the conduct is all set out at 163 to 165. It included an attempt by doctors to pressurize her not to have an abortion, a requirement to speak to a priest, the issue by the hospital of a press release which led to a campaign of harassment of her in the media, the applicant's enforced separation from her mother, and perhaps most striking of all, the decision to prosecute her, a rape victim, for unlawful sexual intercourse. Now, it is not difficult to see, and we would say that actually the Lord Chief Justice was entirely justified in saying it is hardly surprising that there was a breach of Article 3 in that case. And that's because in that case, within the framework of domestic law, which entitled her to an abortion, the positive acts of the medical professionals inflicted on her suffering which reached the Article 3 threshold. In other words, that's a negative obligation case. And all that goes to show the court's focus on the moral characterization of the state conduct in issue. And I note as well, ask the court to note, Judge De Gaetano's dissenting opinion, which you'll find in 1140, MS 1140, which makes the point that the case did not establish or reflect any convention right to abortion, but rather was about how to enforce a right granted by domestic law in the face of opposition, direct or oblique, from public authorities. And that's why he was prepared to join the finding that the conduct of the state authorities gave rise to a violation of Article 3 on the facts of the case. Now, pausing there for a moment, if one asks the question whether the position would have been the same if the relevant medical services had been unavailable, not because of failings for which the state medical or other authorities were morally culpable, but because substantive domestic law did not permit them, we say clearly not. First of all, it would be a positive obligation case, and secondly, there would be no analogue of the conduct that in the Polish cases was described, you may think aptly, as shabby or callous or debasing or humiliating. Now, my fifth proposition, I'm just going to state and give you the references in view of the time, and that is that the Strasbourg Court has never found a violation of Article 3 in a case where an applicant has been denied an abortion because of a substantive legal prohibition. And we would go further and say that there is, in fact, a profound difficulty in seeking to characterize in that way the application of a law which reflects a democratic balancing of admittedly important human interests.
Sorry, what was it? Never found violation in a case where it's been denied abortion and then...
Because of a substantive legal
it's
prohibition.
because, yes,
So,
where there's
so
no
what I'm trying to
entitlement,
do
yes.
is distinguish...
It's quite, no, I've got that.
Yes. Now, obviously, A, B, and C is a case where the Grand Chamber did have to examine a substantive legal prohibition, and it had to ask the question whether the effect of that substantive legal prohibition gave rise to a breach of Article 3. And you have our points in our written case on A, B, and C. Obviously, the Irish law in issue there was notably more stringent than the Northern Irish law under challenge here. It permitted abortion only where the life of the mother was at risk. There wasn't any exception referable to health. The facts of that case show that the suffering endured by the applicants was, on any view, considerable. It's all set out at paragraphs 14, 19 to 20, and 22 to 24. And yet, the Article 3 claim wasn't even arguable. It was manifestly ill-founded. Now, of course, Ms. Leven says, well, that case is very different because it wasn't dealing with rape, incest, or serious fetal abnormality. And we accept that those facts, of course, were not engaged in A, B, and C. But we also accept, of course, that rape, incest, and serious fetal abnormality are all factors that may, in an individual case, add to the distress felt by a woman who cannot obtain an abortion in the place where she lives. But they are not the only such factors. Mr. Justice Horner made this point at paragraph 121 of his judgment. His example was that of a young woman who's become pregnant as a result of a consensual act, but who, because of her psychological makeup or personal circumstances, suffers stress because of the non-availability of abortion in the place where she lives. The facts of A, B, and C are more vivid still, and I do invite the court to look at the facts of that case, which, as I say, were found not even arguably to engage Article 3. Now, I have very little time left because the attorney needs to address Article 8 and Article 14. But can I quickly make some points on the international materials? There are 3 points to make on these materials. The first is this. The principle on which Ms. Leven relies to admit the international materials and for their relevance is the principle established by the Strasbourg court in the Neulinger case. That was a case where the applicants were complaining under Article 8 about a decision of the Swiss courts taken under the Hague Convention on child abduction, requiring the child's return to Israel. Now, the important thing about that case is it was the state that was relying on international law as justifying why its domestic courts had ordered the return of the child. So it was relying on international law in defense, if you like, to the Article 8 claim. Now, in that context, one can quite understand why the Strasbourg court held that the European Convention mustn't be interpreted in a vacuum and must be interpreted in harmony with international law. Otherwise, the state would be subject to 2 conflicting international law obligations pulling in different directions. And that's also the reasoning that you see in the cases on, for example, state immunity, where somebody, or diplomatic immunity, I know this court's been dealing with diplomatic immunity recently, where somebody comes to court and says, well, Article 6 entitles me to a fair hearing, entitles me to have my case considered by a court. The state says, no, we can't do that because that would infringe our obligations under international law. It's quite easy to see the strength of the principle that says that the convention must not be interpreted in such a way as to put states in breach of their other international law obligations. But Ms. Leven can't say here that you have to reject our reading of Article 3 of the European Convention, otherwise the UK will be under conflicting international law obligations, because on our reading there is no conflict at all. We say Article 3 imposes no obligation on states as to the substantive content of their abortion law, and that leaves them entirely free to adopt laws that comply with the Human Rights Committee's reading of, for example, Article 7 of the ICCPR, if they wish to do so. What Ms. Leven is actually relying on here appears to be a different principle, a principle which seeks to avoid conflict, not a principle which seeks to avoid conflict between international law obligations, but a quite different principle that seeks uniformity of interpretation between different instruments covering similar subject matters. If there is any such principle, it is a much weaker one than the true Neulinger principle. Now, I'm going to have to...
Mr. Chairman, before you move on, if I may,
yes.
it may be said against you on that there are other authorities in Strasbourg which adopt a more generous view to looking at international agreements and customary international law. For example, in the area of state immunity cases like Al-Adzani, where a much wider view is taken.
Well, I mean, Al-Adzani is a good example because that's a case where a claimant is saying, you must hear my case because otherwise there'll be a breach of Article 6. The state responds to that claim by saying, well, you can't read Article 6 as requiring us, the courts, to entertain cases of this kind, because if you did, we would be in conflict with international law. And so that is a true conflict case, Al-Adzani. The point I'm seeking to make here really is that the use that Ms. Lieven is trying to make of international law is a different use from the Neulinger principle. What she's trying to do is say, you should interpret Article 3 in a way that is similar to the way that the Human Rights Committee has interpreted some totally different instrument. And we say that if there is any such principle, it is a much weaker one. I'm going to have to sit down, but there are two further points which I hope I can make in one sentence. One is that the court should be very cautious about giving weight to the decisions of the CEDAW and Human Rights Committees, because both of those committees had already expressed their view about abortion generally at the time of the Grand Chamber's decision in A, B and C, and the Grand Chamber took into account their views in its judgment. So those views cannot be regarded as new developments since the Grand Chamber's judgment in A, B and C. And the final point relates to the Committee on the Rights of Persons with Disabilities. Now, what's said against us is, well, that just doesn't apply pre-birth. Well, they can't have it both ways. If they're going to rely on the treaty bodies in relation to one set of instruments, CEDAW and the ICCPR, then it must be open to this court to also look at the view of the relevant treaty body in relation to its instrument, the UNCRPD. And that treaty body does say that there is a problem with abortion law which allows abortions on the basis of disability. It says that there is a problem with abortion law which allows selective abortion on the basis of disability, and of course that is exactly the exception that Ms. Lieven urges on the court in terms of serious fetal abnormality. Ladies and Lords, I'm going to hand over to the Attorney.
Thank you very much, Mr. Chamberlain. Thank you.
My ladies, my lords, there are many good reasons why one might wish that Joseph Goebbels had not lived. That he had a club foot isn't or shouldn't be one of them. The severely disabled, including those so disabled that as unborn children it is believed they will die shortly after birth, are as entitled to life as unborn children who are regarded as normal or perfect. The unborn child whose father is a moral philosopher doesn't have a greater right to life than she whose father is a rapist. In Professor Harris's affidavit, he seeks to denigrate a concern for the disabled by pointing to the existence of disability as a ground for abortion and saying, oh, it's just the same as having hospitals and clinicians who treat disability. Well, it's an unfortunate error for a philosopher to make. The purpose of hospitals and clinicians is to assist disabled people by removing the impact of their disability. aborting disabled people removes the person at the same time as the disability. And the reference to Professor Harris is MS 10286 in Core Volume 5. I had planned to deal with 6 points: Article 8 generally, fair balance under Article 8.2, looking specifically at the role of Article 2 and Article 2 taken together with Article 14, fair balance thirdly, looking at the impact of the UN CRPD, fourthly, fair balance in the specific context of life-limiting conditions, fifthly, the effect of the Irish Concerns Protocol to the Lisbon Treaty, and then sixthly, Article 14. But can I say that I will see how I get on.
I hope you do have time to cover all of those points, Mr. Attorney.
Well, I hope so too, lady. Although the Convention, this is the first point, confers no freestanding right to abortion, it is well established that prohibitions on termination, in cases where there is an impact on life and health, do engage Article 8. I'm going to ask the Court to look at some stage at A, B and C. It's in Authorities Volume 3, but not just at the moment, but if you would have it ready to hand, because I want to ask the Court to look at it for 2 points. I'll be asking the Court to look at it in relation to Article 14, right at the end of these submissions, and also in relation to the point raised by my learned friend Ms Gallagher yesterday afternoon when she hinted that there might be an issue about whether or not the Northern Ireland prohibition on abortion satisfied the first requirement under Article 8.2, that is, was it in accordance with law? And she sought to derive some comfort from the finding of a violation with respect to the third applicant in A, B and C, because the third applicant was unable to ascertain in any satisfactory way under the Irish domestic law whether she would qualify under the Irish Constitution. Of course, the answer to that really lies, and I'll try to express this as compactly as I can. The Irish constitutional protection contained in the 8th Amendment to the Irish Constitution, and one sees the 8th Amendment in A, B and C. I won't look for it elsewhere. It's in Authorities Volume 3, MS page 825, at paragraph 36. The state acknowledges the right to life of the unborn and with due regard to the equal right to life of the mother, guarantees in its laws to respect and, so far as practicable by its laws, to defend and vindicate that right. So it's the equal right to life. Northern Ireland law, to put the matter in very short compass, does not rest on an equality between the unborn child and his or her mother. Where the interests of the mother's life or long-term health are in jeopardy, then the decision of the Northern Ireland legislature, interpreted consistently by the courts, is that the decision is in favour, the life of the mother is preferred. That's been clear from Bourne and the charge to the jury of Mr. Justice McNaughton. So the issue of the uncertainty that arose in A, B and C in trying to ascertain where the balance, the supposed equality of the unborn and its mother lay, doesn't arise in the law of Northern Ireland. Turning then, if I may, then to the proportionality analysis that falls to be undertaken under Article 8. We'll adopt the 4-stage Bank-Mellett test. My ladies, my lords, have that at Authorities Volume 6, tab 50, MS 2048. Those 4 stages are so well known that I needn't go through them. Sufficiently important objective, we say that the unborn child and the protection of the right of the unborn child is a sufficiently important objective. It's protected in the common law of Northern Ireland. We make a reference to Cook's Third Institute, which was cited yesterday in Attorney General reference number 3. Our citation of Cook is at Authorities Volume 19, MS 6809. The important point about that is that what Cook is emphasising is not that abortion is not a crime at common law. It is. It is a great misprision. That's a misdemeanour. It's simply not murder or manslaughter, which of course was the point of Attorney General's reference number 3. We say that the common law in Northern Ireland inevitably takes its colour from statute. The Northern Ireland coronial system has a framework that embraces a child capable of being born alive. Reference to Attorney General against Senior Coroner. Authorities Volume 6, Tab 46, at MS 1939, paragraph 31.
Can I ask, Mr. Attorney, is the objective of protecting the right of the unborn child to life one that can apply if a child is not capable of being born alive?
Yes, because there is an issue, of course, of a clinical judgment as to whether the child will die at birth or shortly afterwards. But if it supposes that there is a space within which the relevant moral certainty doesn't exist, then a child who is capable of leading even a short time has a valuable life, just as worthy protection as a child who will develop, one hopes, in the normal way. And one uses the end of life for a relevant comparator. One wouldn't say, society wouldn't judge the life of a terminally ill person in the last days, hours, or minutes of her or his existence as less worthy protection, say perhaps in a battlefield trial situation, than anybody else. Is there a rational connection between what the law seeks to achieve? We say yes, that as Lord Justice Weatherup noted, we say correctly at paragraph 150 of the Court of Appeal judgment. That's at Core Volume 1, Tab 9, MS 8821, going to 2 over the page. It could be reasonably inferred that the more restrictive the prohibited scope for abortion, the fewer will be the terminations that are likely to occur. And if the court would look at Core Volume 3, one will see MBRRACE UK perinatal mortality surveillance report, and that's at MS page 9761. So there's a table which shows stillbirths in Northern Ireland and neonatal deaths. And the commentary is interesting. Of note, the rate of intrapartum, reading just after Chapter 2, a third of the way down that second substantive paragraph. Of note, the rate of intrapartum stillbirth in Wales significantly higher than that observed in England, Northern Ireland, and the UK as a whole. In Northern Ireland, the stillbirth rate decreased, having been above the UK average. However, the neonatal mortality rate for Northern Ireland was significantly higher than that observed in both England and the UK as a whole. It is important to note that stillbirth and neonatal mortality rates are affected by differences in the law in Northern Ireland relating to termination of pregnancy, with more babies with major congenital anomalies being carried into the later stages of pregnancy and resulting in early neonatal deaths. So I think in answer to a query raised by my Lord Wilson about how one assess the effectiveness of the law, this was a questioning we learned from Mr. Hill about the 100,000 figure. I think one can safely infer from this table that the law of Northern Ireland is capable of affecting the category of unborn children with defects, fetal abnormalities, because they are surviving, they are being born, and they are dying shortly afterwards. Can I, since the court will have Core Volume 3 open, simply ask the court to look very briefly at the some of the few examples. I simply give the court the note at MS page 9657, running to MS 9659. One has examples. I don't say they're the other side of the coin. These are women who have received either a terrifying diagnosis with respect to their children and have proceeded with the pregnancies and the outcome of them doing so. The third Bank Millet question is whether the measures are no more than is necessary to accomplish the desired objective, the least intrusive option test. Of course, as my Lord Reid observed in Bank Millet at MS 2048, the difficulty with it, phrased in absolute terms, is that a judge with a decent imagination can nearly always think of something that is less intrusive than the existing law. The important aspect of Lord Reid's approach to this issue is, it seems to us, in emphasising that particularly in a devolved framework within the United Kingdom, that there must be space for devolved legislatures to reach their locally tailored solutions to these difficult questions. And a little coda to that, perhaps, insofar as complaint is made specifically about the maximum penalty under Section 58 of the 1861 Act of Life Imprisonment. Of course, there is a severability, firstly, with respect to that, and of course one knows that in practice nothing like that would ever be imposed. And the Court of Appeal, in appeal from any sentence moving even close to that, will bring the matter swiftly under control. And then, of course, one turns to fair balance in general, and that is the residual category where the court looks back and assesses for itself whether the Article 8 test in this context is properly met. Putting into the balance, we say, are the Article 2 protections of prenatal life in Northern Ireland. It's clear from Vaux, reinforced in A, B and C, that it is for the state to decide if it will confer Article 2 protection. And it's legitimate for the state to confer Article 2 protection on the unborn child. But even if one doesn't, even if the court isn't with me on that, what we say with some confidence is that Northern Ireland has put the unborn child fairly and squarely within the ambit of Article 2 protection. Whereas if the unborn child comes within the ambit of Article 2, and we say she or he does, then Article 14 applies. And clearly, discrimination on the ground of disability, selecting an unborn child for abortion purely on the basis of disability, would offend the combination of Article 2 taken together with Article 14. That's a matter which we say inevitably must fall into the balancing exercise.
Doesn't it follow that the 1967 Abortion Act is contrary to the Convention on your submission?
Well, the In England, Wales and Scotland, the state, it would be argued, hasn't chosen to extend Article 2 protection at all to the unborn child. So that issue wouldn't arise. But I do say, coming to my next point, that there might be an issue as far as the UN Convention on the Rights of Persons with Disabilities might be concerned. Because plainly, the committee has looked at that, give the court the reference in a minute, and has criticised the United Kingdom for the regime under the 1967 Act, which expressly approves discrimination on the ground of disability in terms of the protection afforded to the unborn child.
Before the enactment of the 1967 Abortion Act, had the state in Great Britain placed the unborn child within the ambit of Article 2 protection?
Well, I suspect the answer to that question, Lord, may take me comfortably past my time, because the starting point is...
Try it in a couple of...
Well, I will. The starting point is that the Strasbourg jurisprudence doesn't reflect the declaratory theory of the common law, that Strasbourg is the developing instrument which my lady President Hale has spoken about with some gentle acerbity, if I may say so. And therefore, the issue might not simply have been consciously addressed. And though, of course, comes comfortably after the 67 Act. So one imagines that the margin, if it had been consciously chosen at all, was left in a way that accorded protection pre-1967 to the unborn child in England, Wales and Scotland. I was turning to the protection afforded by the UN Convention. And of course, two of the three categories identified by the appellant in this case relate to disability. And we make reference to the Convention, to Article 10 of the Convention. It's at Authorities, Volume 5, MS 1685. We also give reference then to the latest report of the committee. That's Authorities, Volume 18, Tab 187, MS 6411. The committee is concerned about perceptions in society stigmatizing persons with disabilities as living a life of less value and the termination of pregnancy at any stage on the basis of fetal impairment. Paragraph 2, the committee recommends that the state party changes abortion law accordingly. Women's rights to reproductive and sexual autonomy should be respected without legalising selective abortions on ground of fetus deficiency. And my learned friend Ms. Leven's quite right. Here I am pointing to a body which plainly contemplates the existence of abortion. She's absolutely right to make that point. The point is, of course, is that the UN committee here, charged with enforcing the Convention on the Rights of Persons with Disabilities, doesn't have an objection to abortion as such. What it does have a profound objection to is to the selection of the unborn for abortion because, sorry, the selection of the disabled for abortion because they are disabled. And one sees the same approach in reports on Spain, Volume 18, MS 6414, and in relation to Hungary and Austria, MS 6415, 6418. Now, echoing what Mr. Chamberlain said, the Commission can't have it both ways. But the important issue for the Northern Ireland authorities, the Assembly and the executive ministers, is that the UN CRPD is EU law for the purposes of a limitation on legislative competence and ministerial power. And one sees the European Community's definition of treaties, United Nations Convention on the Rights of Persons with Disabilities, Order 2009, in Authorities Volume 15, at tab 149, MS page 6462. And in just for the court's note, the court will see that the definition of EU law contained in section 98 of the Northern Ireland Act 1998, Authorities Volume 5, MS page 1575. EU law means all rights, powers, liabilities, obligations and restrictions created or arising by or under the EU treaties, and all remedies and procedures provided for by or under these treaties. So the UN Convention is an EU treaty. Then, very quickly, I won't deal with the life-limiting disabilities because I hazard that I've made the core of my submission in reply to my Lord Reid. Can I ask the court then to take up the SPUC bundle of authorities? And at tab 11.
Do we have an MS number for that?
No, we don't. It's completely unpaginated. I'm sorry, but it's.
They just arrived yesterday.
They just arrived yesterday, so it's. It is a little difficult to use. At tab 11. The court will find the Protocol on the Concerns of the Irish People on the Treaty of Lisbon. And at Article 1 of the treaty, nothing in the Treaty of Lisbon attributing legal status to the Charter of Fundamental Rights of the European Union or in the provisions of that treaty in the area of freedom, security and justice affects in any way the scope and applicability of the protection of the right to life in Article 43.1, Article 43.2 and 43.3. That's the 8th Amendment. And it then goes on to deal with other issues such as the protection of the family and so forth. But I draw attention to it for that. So Ireland's constitutional protection of the right to life of the unborn is a protocol to the Lisbon Treaty. It's therefore protected from challenge, entirely consistent with EU law. And we say that has a number of effects, but not the least is it brings to bear the Bosphorus doctrine. And I see that Bosphorus is in the SPUC authorities at tab 8. And if one turns to the discussion from paragraph 159 to 165. So Bosphorus has become famous, thumbnail, that if something passes muster in terms of EU fundamental rights protection, then there is the presumption that it passes muster in convention terms also. And we say that's a matter of enormous significance. And perhaps a little surprising that it hasn't played a more prominent part up to now. And of course, in terms of sequencing, the court may be interested to know that comes after the decision of the Grand Chamber in A, B, and C. So the partial violation found with respect to the third applicant in A, B, and C doesn't in any way undermine the prospective impact of this protocol, coming as it does after the Grand Chamber decision. Finally, and I hope very briefly in relation to Article 14. Article 14 in classic...
How do we know that Bosphorus would apply in this situation? It sounds rather interesting let out from scrutiny for a particular country. You get something, qualification in EU terms, and then has the effect, knock-on effect of changing your reviewability in Strasbourg.
Well, it's a presumption.
Bosphorus itself is well, I don't know, it hasn't been reconsidered recently, has it? But anyway, leave it.
No, well, it's interesting. When one looks at some of the concurring judgments, they express the view that this demonstrates the importance of the EU signing up to the convention, as it is obliged to do. So if a case were to come now after opinion 213, who knows what might become of Bosphorus? But there it is.
All right. Anyway, it's a novel point.
It is. But nonetheless, one has a striking protocol to the Lisbon treaties, and one has Bosphorus. Finally, my ladies, my lords, Article 14. Again, applying classic convention jurisprudence, one looks for relevant comparability. And there simply isn't relevant comparability in this case. And it is, the court I know is familiar with A, B and C against Ireland, and will have looked at the were of course a dissenting opinion, but it's striking that even in the dissenting opinion, the approach of the court, of course, as the court will know, is to not give Article 14 separate consideration, but even the dissenters in A, B and C against Ireland don't revisit the issue of Article 14. Article 14 simply doesn't bite in this case. And if, contrary to our submission on that, the court considers that it does, then for essentially the same reason as we say that the Article 2 test is more than satisfied in Northern Ireland, then that plays too with respect to Article 14. Well, someone famously before the US Supreme Court offered to make the court a present of a minute. I've always wanted to do that, so may I make the court the present of a minute?
Oh, Mr. Attorney, we are most grateful for your generosity. Thank you.
In reciprocal arrangements, Mr. Attorney, since we gave you plenty of time to make your submission.
Well, that said, with reciprocal gratitude, we will adjourn until 2 o'clock.